I'm going to ask Susan to open by explaining the case and what happened today.
Thank you. Do you want me to? Okay. Thank you all for coming. Today the legal team filed a case on behalf of preterm, the ACLU, against the state of Ohio and various agencies challenging the 3 amendments to the Ohio budget bill, which we believe are unconstitutional because they did not follow the single subject rule of the Ohio Constitution. Those 3 amendments, excuse me, I need my glasses, ban public hospitals from making transfer agreements with abortion clinics. So it essentially bans public hospitals from agreeing to accept women in distress after they've had an abortion. Another amendment requires clinics to follow a government script and specifically testing women for the evidence of a fetal heartbeat and offering that evidence to the woman, and even if it is against the physician's medical judgment to do so, and it is a criminal offense. So physicians could be charged with criminal offenses for not giving a woman a specific scripted amount of information. And the 3rd amendment creates the Ohio Parenting and Pregnancy Program, which siphons state money directly to private organizations that give information on pregnancy, but they are prohibited from giving any information at all about abortions. At a very fundamental level, this is a case about good government. These amendments were placed into the budget bill at the 11th hour without any opportunity for people to discuss this with their legislators, and constituents had no opportunity to give input. None of these amendments had any place in the state budget bill. The Ohio Constitution makes it very clear that legislation is to be for a single subject only. The state budget bill is for the appropriations of the state budget. None of these amendments have anything to do with the state budget. You don't need to be pro-choice to understand that these tactics do damage to our governmental system, and it was just fundamentally wrong to pass these amendments at the last minute. Thank you.
Susan.
Thank you. Yeah, I just want to make a couple of points. First of all, that many of these amendments were originally, at least in part, introduced in the form of standalone bills that themselves never had enough support to pass as standalone legislation. These are controversial, highly controversial pieces of social legislation that were snuck into a must-pass budget bill in the 11th hour without an opportunity for public debate or input from constituents. There is a name for this practice. It is called log rolling, and as Susan said, it is precisely the type of conduct that the Ohio Constitution is meant to protect against. And so, in short, this is bad government. It's also bad medicine and bad health policy.
Thank you, Joseph. Chris?
We know that ostensibly these laws were passed because of what we keep hearing is that to protect women's health. Let me tell you and assure you that none of these have anything to do with protecting women's health. With a transfer agreement, for example, no hospital is going to refuse somebody who shows up on their doorstep. They cannot refuse care. Abortion clinics are the only ones that have this requirement. And in many towns where we happen to be fortunate in Cleveland area because we have so many healthcare facilities, where this is really damaging is in some rural areas where there may not be hospitals available, or there may be a Catholic hospital where they can't get a transfer agreement. The heartbeat requirements and providing statistical information about the probability of carrying a pregnancy to term is cruel. It's cruel to women, and it's unnecessary by part of their health care.
So we've heard today from the folks in Ohio, and I'm here to give a little bit of the national perspective. This isn't just an Ohio story. We've seen politicians with help from national extremist groups introduce these kinds of provisions across the country. With respect to the transfer agreement requirement here in Ohio, it's very similar to requirements we've seen across the country requiring doctors to have admitting privileges at local hospitals, and it creates the same situation where you have a completely unnecessary regulation targeted exclusively at abortion providers that puts the ability of those providers to provide care in the hands of local hospitals. And again, laws already require, hospitals to admit women, if in the rare case that they need emergency care, into those hospitals, into those emergency rooms. So privileges, laws, or transfer agreements we've seen introduced in at least 5 states this term. With respect to the heartbeat provisions, we've seen ultrasound laws introduced in at least 18 states this year. And with respect to state funding of what we call crisis pregnancy centers, we've seen that introduced in at least 7 states, where state money is being funneled to groups that are forbidden to speak about abortion. Again, this, as Chris says, this isn't about protecting women's health. It's a backdoor attempt to shut down safe providers. We may not all feel the same way about abortion, but it's important to protect women's health by keeping these providers open. Thank you.
Thanks, Renee. For the reporters that are in the room that may need to leave quickly, all of the speakers will be available throughout the day for additional background or interviews by contacting our communications staff, Nick Warner. And you can reach Nick at nwarner@acluohio.org. Also, all the documents from the filing today and today's press packet will be posted on our website momentarily if they're not there already. So if you want a copy of the complaint, go to acluohio.org, and a filed stamped copy is available to you there. We'll take questions from the audience and from reporters if there are any. We do know, Susan, who the judge assigned is, and maybe you or Professor Hill would like to address the potential timeline on the case.
Well, the judge who has been assigned to the case is Judge Michael Rousseau. The state has 30 days, which they can always receive an extension for, in which to file an answer, and then the case will proceed through the courts. We really don't know at this point what the time is.
Right.
It will not be quick.
Jesse, do you want to talk a little bit about the state court system? What happens when you lose a trial?
Right. So we have this is not a federal lawsuit. We filed suit in the Common Pleas Court for Cuyahoga County. So that's the trial court level. Right. As Chris Link just said, win or lose, there will likely be an appeal up to the 8th District Court of Appeals, and then ultimately our final level of appeal would be in the Ohio Supreme Court. So it would probably be expected that the case would end up there eventually, but of course that's potentially a very long timeline for that.
Pardon me if you've already covered this, but does this raise a possibility of any kind of stay on these?
Go ahead.
We are filing for an injunction, although not a temporary restraining order. So that is what we are asking for, but it would not be an immediate stay. We actually have sued a number of plaintiffs. When you look at the complaint, we have filed against the state of Ohio and Governor Kasich because we believe that these provisions of the bill are unconstitutional. We have also filed against the state medical board because the state medical board has the right to enforce disciplinary measures on any physicians who fail to give the fetal heartbeat information to the woman. We have filed against the county prosecutor because the prosecutor is the one who is to enforce criminal sanctions against physicians who fail to give the information to the woman. And we also have filed against the State Department of Health because that is the department that enforces the transfer agreements, and against the Department of Job and Family Services because that's the department that creates the pregnancy and parenting funding, or filters the funding to the organization. So we have asked for an injunction against all of these organizations from enforcing the bill, but there won't be an immediate stay.
Thank you. Chris France, as Executive Director of Preterm, perhaps you could lay out the process of an uncomplicated first trimester abortion. If a woman visits your clinic, what is that like?
Well, in Ohio, there is no such thing as an uncomplicated abortion now. It was easier to get an abortion in 1980 than it is today. One of the first things that a woman has to do is call and make an appointment. When she comes in for her first visit, she goes through counseling, has an ultrasound, gets medical history taken. The last thing she does on that first day is meets in a private setting with a physician, and the physician has a state-mandated script that he or she has to tell the woman, and then they sign for informed consent. At least 24 hours later, she can come back for her procedure. If she possibly wants a medication abortion, that procedure now, because of Ohio law, requires 4 visits, not just 2. If she's in the second trimester, there are a whole slew of other laws and regulations that have to be followed. Ohio has something called a post-viability ban, which means that anything past 20 weeks, you have to do viability testing. There is no such thing as viability testing. And I think what it does is every time one of these things goes through, we have women call us and say, is abortion still legal in Ohio? The other thing that it's done is because of the number of regulations is that women are choosing to go out of state for abortion procedures. If they want a medication abortion, they can go to Pennsylvania, they can go to Michigan. It's a lot easier. And the real impact of these regulations is that it forces doctors to practice medicine in a way that is mandated by law rather than medical judgment, and I think that's the real harm. And the other thing that it does is it's cruel and it shames women, and women think long and hard about this, about what's best for their families, and these laws do absolutely nothing to protect women's health.
Renee, you mentioned the national trend of regulation of clinics, and a number of us have worked in the field for a long time. We know that some of those regulations started in Akron, Ohio, 30 years ago. How is this going to limit abortions across the country?
Well, our opponents have, the national extremist groups have figured out that the way to outlaw abortion is sort of by passing what may sound like innocuous laws, but that are targeted regulations of abortion providers designed to make it impossible to continue to provide safe and legal abortions to women. So, in Ohio, we see this written transfer agreement law. In Texas, we saw admitting privileges law that would shut down 1/3 of the clinics in the state. We saw similar laws in Mississippi that would have shut down the only clinic left in that state, in Alabama that would have shut down 3 of 5 of the clinics in that state. And all of this from a law that sounds as innocuous as requiring a doctor to have admitting privileges, when the truth is it's not required by medical practice. It's the state intruding upon abortion clinics in a way they don't upon other medical providers. It's completely unnecessary to protect women's health and safety, and in fact it hurts women's health and safety by shutting down clinics.
So, questions?
I know one of the issues is Toledo, right? Where one clinic shut down and we're state's left with one more there, and I know the transfer agreement was a big issue. How does this lawsuit affect the status of the Toledo clinic?
Well, so the Toledo clinic is not one of the plaintiffs in this lawsuit. If this lawsuit ends up being successful, what it would do would be to eliminate the legislative requirement in the budget bill for the written transfer agreement. However, the Department of Health has been enforcing a requirement like that under its regulations. It's just differently drafted and not as harmful. It doesn't give as much unbridled discretion, for example, to the Director of Health to rescind waivers and things like that. So there are differences between the provisions. This one is more onerous. So it would lift this more onerous requirement. There would still be a written transfer agreement requirement in place.
And as it is, they're still looking for a transfer agreement with one of the local hospitals. Is that the case right now?
I don't know. I can't speak for them.
Yeah. Yeah, the effect of these transfer agreements will be very practical and probably felt within a year, we think, is that a number of clinics will not be able to establish transfer agreements and will go from having multiple providers with a lot of choice for women to one or two providers and almost no choice for women on where they go for care or the distance they have to travel. So if you think about this for yourself in medical care, do you want to have a lot of choices on where to get your medical care, or do you want to be limited to only a choice, and a choice that might be 3 or 5 hours away from where you live?
Yeah, and I just want to emphasize that one of the key differences between the prior law and what was enacted with the budget is that public hospitals cannot enter into written transfer agreements. So that is really troubling for a number of clinics that have agreements with public hospitals, and it really will absolutely affect access. And especially in the more difficult, complicated cases, which are out there, it's going to really reduce the number of providers that are able to handle those cases.
And once providers are reduced, coupled with the 24-hour waiting period that we already have, you're talking about women needing to travel significant distances and either go back home and come back or to stay, and that's going to really have a very disparate impact on women without resources to travel and to stay in another city. It's very onerous.
Is there precedent? You're talking about this as bad government. Is there precedent where the things have been put into the budget before, not having to deal with women's health, that have gone past surgery? There have been lawsuits in the past attacking this 11th hour.
Absolutely.
Yeah, I'm not aware of any in this particular context of women's health or reproductive health, but there are a number. There's a very solid precedent in Ohio that enforces this single subject rule, this one subject rule. As a matter of fact, just to give an example that everyone might recollect, is that initially the Cleveland school voucher system was added as part of the budget bill and was struck down on that basis. So there is a strong history of the Supreme Court, Ohio Supreme Court, the lower courts enforcing this requirement and taking it quite seriously. It's not a technicality. There's a reason for it, which is that legislation should be subject to public debate and it shouldn't be snuck into bills like this.
Other questions? I think what we'll do is conclude now. And make 4 opportunities for individual interviews with reporters, if that suits everybody. So thank you all for coming.